Good day, everyone. We are Baisa, Bautista, Pujalte, and Valenzuela of Group 6, and we will be reporting on recent and relevant jurisprudence on the constitutional provisions of freedom of religion, liberty of abode and travel, non-impairment of contracts, rights under investigation, right to bail, and rights of the accused, respectively. I will give the floor now to Mr. Baisa.
So the first topic that we will be reporting on is the constitutional right to freedom of religion. Peralta versus Philippine Coastal Corporation. GR number 223395, December 4, 2018. The pertinent facts are as follows. Respondent Philippine Postal Corporation issued a stamp commemorating Iglesia Ni Cristo centennial celebration. The design of the stamp showed a photo of INC founder, the late Felix Y. Manalo, with a designation on the left side containing the words Felix Y. Manalo, 1886 to 1963, first executive minister of Iglesia Ni Cristo, with a central temple on the religious group at the background at the right side of Manalo's photo in the INC centennial logo, which contained a torch enclosed by a two concentric circles containing the words Iglesia Ni Cristo, centennial 1914 to 2014. Petitioner Renato Peralta filed a complaint for injunction with the Regional Trial Court. He alleged that the printing and issuance of the INC commemorative stamp involved disbursement of public funds and violated Section 29, Paragraph 2 of Article 6 of the 1987 Constitution. He argued that the respondent's act of releasing said stamps was unconstitutional because it was tantamount to sponsorship of religious activity. It violated the separation of the church and the state and the non-establishment of religion clause. So the issue in this case is whether or not the printing of the INC centennial commemorative stamps violated the principle of inviolability of the separation of church and the state and the non-establishment of religious clause. The Supreme Court ruled against the petitioner. It said that the wall between the church and the state exists along with the recognition of freedom of religion. In fact, review of jurisprudence would reveal that this court has carefully weighed these principles as to allow the broadest exercise of religious freedom without infringing the non-establishment clause. In upholding the issuance of the 33rd International Eucharistic Congress commemorative stamp, this court in Aglipay v. Luis recognized how religion is integrated in the Filipino way of life. The more important question raised refers to the alleged violation of the Constitution by the respondent in issuing and selling postage stamps commemorative of the 33rd International Eucharistic Congress. It is alleged that the action of the respondent is violative of the provisions of Section 13, subsection 3, Article 6 of the Constitution of the Philippines, which provides as follows. No public money or property shall ever be appropriated, applied, or used directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or for the use or benefit or support of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution, orphanage, or leprosarium. The prohibition herein expressed is a direct corollary of the principle of separation of church and state, without the necessity of adversing to the historical background of this principle in our country. Moreover, freedom of religion has been accorded a preferred status by the framers of our fundamental laws. Past and the present, the court has affirmed this preferred status, well aware that it is designed to protect the broadest possible liberty of conscience, to allow each man to believe as his conscience directs, to profess his beliefs, and to live as he believes he ought to live, consistent with the liberty of others and with the common good. The court has also laboriously defined in our jurisprudence the intersecting umbras and penumbras of the right to religious profession and worship. To quote the summation of Mr. Justice Sagani Cruz, our well-known constitutionalist, the right to religious profession and worship has twofold aspects. First, the freedom to believe and freedom to act on one's belief. The first is absolute, as long as the belief is confined within the realm of thought. The second is subject to regulation, where the belief is translated into external acts that affect the public welfare. In Estrada versus Escritor, this court encapsulated its policy towards these kinds of disputes as benevolent neutrality. Benevolent neutrality recognizes the religious nature of Filipino people and the elevating influence of religion in society. At the same time, it acknowledges that government must pursue its secular goals. In pursuing these goals, however, the government might adopt laws or actions of general applicability which inadvertently burden religious exercise. Benevolent neutrality gives room for accommodation of these religious exercises as required by the Free Exercise Clause. It allows these breaches in the wall of separation to uphold religious liberty, which after all is the integral purpose of the religion clauses. The case at bar involves this first type of accommodation, where an exemption is sought from a law of general applicability that inadvertently burdens religious exercise. Also, the Lemon Test, which has been extensively applied by the U.S. Supreme Court in issues involving the determination of non-stable establishment of religion laws, originated from the case of Lemon versus Kurtzman. In that case, the court used a three-pronged test to adjudge whether the sealed governmental act violated the First Amendment, as follows. First, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances nor inhibits religion. And the third, the statute must not foster an excessive government entanglement with religion. So did the commemorative stamp amount to the violation of the non-state establishment of religion clause? The Supreme Court said no. The printing of the INC commemorative stamp did not amount to a violation of the non-establishment of religion clause. As to the 50,000 stamps ordered, printed, and issued to INC, the same did not violate the constitutional prohibition separating the state from state matters from religion. It is plain that the costs for the printing and the issuance of the aforesaid 50,000 stamps were all paid for by the INC. Any perceived use of government property, machines, or otherwise is de minimis and certainly do not amount to sponsorship of a specific religion. Also, there was no violation of the constitutional prohibition on establishment of religion insofar as the remaining 1,150,000 pieces of the stamps printed and distributed by Philpost. First, there is no law mandating anyone to avail of the INC commemorative stamps, nor is there any law purporting to require anyone to adopt the INC teachings. Moreover, as to the use of the government's machinery in the printing and distribution of the 1.2 million stamps, this court does not find that the same amounted to sponsorship of INC as a religion, considering that the same is no different from other stamps issued by the Philippines, acknowledging persons and events of significance to the country, such as those printed celebrating national artists, past presidents, and events of organizations, religious or not. Based on the foregoing, this court is not convinced that the Philippines has actually used its resources to endorse nor encourage Filipinos to join INC or observe the latter's doctrine. On the contrary, this court agrees with the respondents that the printing of the INC commemorative stamp was endeavored merely as part of Philippines' ordinary business. In the same vein, the court did not find that there was illegal disbursement of public funds under Section 29, Paragraph 2 of Article 6 of the Constitution. The court, citing red letter of Tony Q. Valenciano holding a religious street was at the Hall of Justice building in Quezon City, which will be discussed later in the report, held that Section 29, Paragraph 2, Article 6 of the 1987 Constitution provides no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution, or government orphanage or leprosaurium. Thus, the words pay and employ should be understood to mean that what is prohibited is the use of public money or property for the sole purpose of benefiting or supporting any church. It has also been held that the aforecited constitutional provision does not inhibit the use of public property for religious purposes, when the religious character of such use is merely incidental to a temporary use which is available indiscriminately to the public in general. In relation thereto, the phrase directly or indirectly refers to the manner of appropriation of public money or property, not as to whether a particular act involves a direct or a mere incidental benefit to any church. Otherwise, the framers of the Constitution would have taken before use, benefit, or support to describe the same. Even the exception to the same provision bolsters this interpretation. Moreover, the design of the INC commemorative stamp is merely an acknowledgement of the historical and cultural contributions of the INC to the Philippine society. Adopting the stance of benevolent neutrality, this court deems that the design of the INC commemorative stamp constitutionally permissible. As correctly held by the Court of Appeals, there is an intrinsic historical value in the fact that Felix Y. Manalo is a Filipino and that the INC is a Filipino institution. To reiterate in the same manner that public property is allowed to be used temporarily by different religions like roads or parks, the philatelic services and products offered by Philpost for valuable consideration can be availed not only by the INC, but by other people or organizations as well. For the above stated reasons, this court maintains its finding that the printing and issuance of the INC centennial stamp did not contravene Section 29, Paragraph 2, Article 6 of the 1987 Constitution. Besides, petitioner's cause of action, which is injunction, then necessarily fail as there is nothing more to restrain or enjoy. The next case is red letter Tony Valenciano holding religious rituals at the Hall of Justice building in Quezon City. The facts are as follows. In his first letter, dated January 6, 2009, Valenciano reported that the basement of the Hall of Justice of Quezon City had been converted into a Roman Catholic chapel, complete with offertory tables, images of Catholic religious icons, a canopy, an electric organ, and a projector. He believed that such practice violated the constitutional provision on the separation of church and the state, and the constitutional prohibition against the appropriation of public money or property for the benefit of sect, church, denomination, or any other system of religion. He also argued that it tended to favor Catholic litigants, that rehearsals of the choir caused great disturbance to other employees, that the public could no longer use the basement as resting place, that the employees and litigants could not attend to their personal necessities, such as going to the lavatories, because they could not traverse the basement between 12 o'clock, noontime, and 1:15 o'clock in the afternoon. On March 23, 2010, Valenciano wrote another letter praying that the rules will be promulgated by the court to put a stop to the holding of Catholic masses or any other religious rituals at the Christian Hall of Justice and in all other halls of justice in the country. When the case was referred to the Office of Court Administrator, the the Office of the Court Administrator advanced the view that the standard of benevolent neutrality or accommodation was espoused because the principal religion clauses in our Constitution were not limited to the Establishment Clause, which created a wall between the church and the state, but was quickly followed by the Declaration of the Free Exercise Clause, which protected the right of the people to practice the religion. In effect, the standard of benevolent neutrality accommodation balanced the interests of the state with the Establishment Clause, and the interest and right of the individual to freely exercise his religion as guaranteed by the Free Exercise Clause. The OCA is likewise observed that the present controversy did not involve a national or local law or regulation in conflict with the free exercise law. So the issue in this case is whether the holding of masses at the basement of the Quezon City Hall of Justice violates the constitutional principle of separation of church and the state, as well as a constitutional prohibition against appropriation of public money or property for the benefit of any sect, church, denomination, sectarian institution, or system of religion. The Supreme Court ruled in the negative. The pertinent constitutional provision reads, Section 6, Article 2 of the 1987 Constitution. The separation of church and state shall be inviolable. This, notwithstanding the state, still recognizes the inherent right of the people to have some form of belief system, whether such may be belief in a supreme being, a certain way of life, or even an outright rejection of religion. In Aglipa versus Ruiz, the court acknowledged how religions serve as motivating force behind each person's actions. It said that religious freedom, however, as a constitutional mandate, is not inhibition or profound reverence for religion. It is not a denial of its influence in human affairs. Religion as a profession of faith to an active power that binds and elevates man's is recognized. And insofar as instilled into our minds the purest principles of morality, its influence is deeply felt and highly appreciated. So, did the petitioner show that there is a compelling state interest? The Supreme Court ruled in the negative, holding that religious freedom, however, is not absolute. It cannot have its way if there's compelling state interest. To successfully invoke compelling state interest, it must be demonstrated that the masses in the QC Hall of Justice unduly disrupt the delivery of public services or affect the judges and employees in the performance of their official functions. In Estrada versus Tutor, the court expounded on the test as follows. The compelling state interest test is proper where the conduct is involved for the whole gamut of human conduct has different effects on the state's interest. Some effects may be immediate and short term, while others delayed and far-reaching. A test that would protect the interest of the state in preventing a substantive evil, whether immediate or delayed, is therefore necessary. As reported by the executive judges of Quezon City, the masses were being conducted only during noon breaks and were not disruptive of public services. The court proceedings were not being distracted or interrupted, and that the performance of the judiciary employees were not being adversely affected. Moreover, no civil service rules were being violated, as there has been no detrimental effect on the public service or prejudice to the state. There is simply no state interest compelling enough to prohibit the exercise of religious freedom in the halls of justice. In order to give life to the constitutional right of freedom of religion, the state adopts a policy of accommodation. So what is accommodation? Accommodation is a recognition of the reality that some governmental measures may not be imposed on a certain portion of the population for the reason that these measures are contrary to their religious beliefs. In Ebralina versus Division Superintendent of Schools of Cebu, the petitioners who were members of the Jehovah's Witness refused to salute the flag, sing the national anthem, and recite the patriotic pledge, for it is their belief that those were acts of worship or religious devotion which they could not conscientiously give to anyone or anything except God. The court accommodated them and granted them an exemption from observing the flag ceremony out of respect for their religious beliefs. On the opposite side, we have the non-establishment clause. It says that no law shall be made respecting an establishment of religion. The non-establishment clause reinforces the wall of separation between church and state. It simply means that the state cannot set up a church nor pass laws which aid one religion, aid all religion, or prefer one religion over another, nor force nor influence a person to go to or remain away from the church against his will or force him to profess a belief or disbelief in any religion. So what are the distinctions between accommodation and establishment? So what are the distinctions between accommodation and establishment? Establishment entails a positive action on the part of the state. Accommodation, on the other hand, is passive. In the former, the state becomes involved through the use of government resources with the primary intention of setting up a state religion. In the latter, the state, without being entangled, really gives consideration to its citizens who want to freely exercise their religion. So is the so is the holding of a mass in the accusal of justice a case of establishment? The court said no. Catholic mass at the basement of the accusing hall of justice is not a case of establishment, but merely accommodation. One of the reasons are first, there is no law, ordinance, or circular issued by any duly constitutive authority expressly mandating that judiciary employees attend the Catholic masses at the basement. Second, when judiciary employees attend the masses of to profess their faith, it is at their own initiative, as they are their own free will and volition, without any coercion from the judges or administrative officers. Third, no government funds are being spent because the lighting and air conditioning continue to be operational, even if there are no religious rituals there. Fourth, the basement has neither been converted into a Roman Catholic chapel, nor has it been permanently appropriated for the exclusive use of its faithful. Fifth, the allowance of the masses has not prejudiced other religions. There's likewise, the Supreme Court likewise ruled that no appropriation of public money or property for the benefit of any church. It has been held that the Section 29, Paragraph 2, Article 6 of the 1987 Constitution does not inhibit the use of public property for religious purposes when the religious character of such use is merely incidental to a temporary use which is available indiscriminately to the public in general. In the case at bar, the basement of the accusing hall of justice is not appropriated, applied, or employed for the sole purpose of supporting the Roman Catholics. Further, it has not been converted into a Roman Catholic chapel for the exclusive use of its faithful, contrary to the claim of Valenciano. Judge Masaren reported that the basement is also being used as public waiting area for most of the day and a meeting place for different employee organizations. The use of the area for holding masses is limited to lunch break period from 12 o'clock to 1 o'clock in the afternoon. Further, Judge Sabon Jr. related that masses run for just a little over 30 minutes. It is therefore clear that no undue religious bias is being committed when the subject basement is allowed to be temporarily used by the Catholics to celebrate Mass. And the same area can be used by other groups of people and for other purposes. Thus, the basement of the QC Hall of Justice has remained to be public property devoted for public use because the holding of Catholic masses therein is mere incidental consequence of its primary purpose. So the last case under freedom of religion is the case of Soriano versus People. In July 1998, Eliseo Soriano, head of the Ang Dating Daan, was indicted for 2 counts of libel. First, he called the leader of the in the first criminal information, he called the lead. It was stated that he called the leader of the Jesus Miracle Crusade International Ministry as Gulaang Propeta, Tarantado, Gago, its pastors as Pastor ng Demonyo, Impacto, Gago, its members as isang dakot na Gago, Siraulo, and in the second information, he called Wilde Almelda, evangelist of JMCIM as pastor ng mga demonyo. This all happened because the pastors of JMCIM, particularly Almeda, supported Joy de Venecia in the 1988 presidential elections, even declaring him as the next president. But de Venecia lost. This prompted Soriano to call the pastors of JMCIM as such. In his defense, Soriano invoked religious freedom. He invoked that his utterances were expressions of religious beliefs. So the regional trial court found the petitioner Soriano guilty of 2 counts of libel, in which the Court of Appeals affirmed. So the so so the issues in this case is whether or not Soriano should be guilty of libel, 2 counts of libel, and whether or not Soriano's remarks are protected by religious freedom. The Supreme Court ruled that Soriano is guilty only of libel only in the criminal case number IR 5273, which is the second criminal information against him. Um, the Supreme Court um, held that for an imputation to be libelous, the following requisites must be present. First, it must be defamatory. Second, it must be malicious. Third, it must be given publicity. And fourth, the victim must be identifiable. In Manila Bulletin Publishing Corporation and Luther Batigas versus Victor A. Domingo and People of the Philippines, the Supreme Court said that a charge is sufficient if the words are calculated to induce the hearers to suppose and understand that the person or persons against whom they were uttered were guilty of certain offenses, or sufficient to impeach the honesty, virtue, or reputation or to hold the person or persons up to public ridicule. From the above mentioned test, petitioner's words stated during his program are clearly defamatory. The word gago, tarantadong pastor ng demonyo yan, bulaang propeta, disparaged private complainant Hilde Almedo. Though religion is arguably a matter of subject of public interest, there is no standard by which we can declare that petitioner statements as fair commentaries. On their own, the words used by petitioner do not appear to debunk the proposed falsities in the teachings of JMCIM, but actually to degrade and insult their pastor or founder, Almeda. The court can only see Soriano's apparent objective of discrediting and humiliating private complainants as to sow the seeds of JMCIM's dissolution and to encourage membership in his religion. As to the element of publication, libel is published not only when it's widely circulated, but also when it is made known or brought to the attention or notice of another person, other than its author and the offended party. In this case, there is no doubt that the video footage of petitioner was published as it was broadcast through petitioner's radio program. However, although the court affirmed the petitioner's guilt of libel, the petitioner's guilt stems from statements against Pastor Almeda and not the JMCIM or any of its pastors, aside from mentioning Almeda's name. Petitioner's statement did not refer to any specific pastor or member of the JMCIM. The court cited MBRS publications versus Islamic Dawa Council of the Philippines. The court said that declarations made about a large class of people cannot be interpreted to avert to an identified or identifiable individual, absent circumstances specifically pointing or alluding to a particular member of a class. No member of such class has a right of action without all impairing the equally demanding right of free speech and expression, as well as the press under the Bill of Rights. The information in criminal case number IR-4848 does not refer to any specific individual or pastor, but merely mentions persons comprising of Jesus Miracle to Say, international ministry. Further, the court did not find anything in the records which establish or single out any specific pastor, specifically Joel Cortero. Neither did the court consider petitioner's statements to be sweeping enough to injure the reputations of all the members of the MCIM. So, as to the issue of whether or not religious freedom of Soriano was violated, the Supreme Court ruled in the negative, citing Soriano versus LaGuardia, stating that plain and simple insults directed at another person cannot be elevated to the status of religious speech. Even petitioner attempts to place his words in the context to show that he was moved by anger and the need to seek retribution, not by any religious conviction. So we now go to the topic on liberty of abode and travel. The first case is Garcia versus Sandigan Bayan et al. The relevant facts are as follows. Following the controversial transaction involving the Balili estate or the purchase of the Balili estate, the Public Assistance and Corruption Prevention Office of Visayas, or PACO Visayas, conducted a fact-finding investigation on the matter. On September 23, 2009, representatives from the Department of Environment and Natural Resources and the Office of the Ombudsman of Visayas conducted a verification survey on the area. The team discovered that 202,456 square meters portion of the 247,317,000 square meter property was classified as timberland. Further, 196,696 square meter portion thereof was underwater. It was likewise discovered that the appropriation for the purchase of the lots was classified as site development and housing program, but no item enumerated thereon included site land acquisition. Apart from this irregularity, it was learned that there was also a question on the legality of the Luis acquisition of ownership over the subject lots, and that the DNR proposed that they be subjected to reversion proceedings. Subsequently, the OMB Visayas, through the PACO Visayas, initiated the filing of criminal and administrative charges against the accountable public officials and employees, pursuant to a letter of complaint from an anonymous sender. Thereafter, another letter complaint dated December 23, 2010, was filed by a certain Manuel P. Manuel, questioning the provincial government purchase of the Baligi estate and requesting that the concerned officials be investigated for violation of Section 3A of Republic Act Number 3019. In a resolution dated August 26, 2011, the OMB Office of the Overall Deputy Ombudsman found probable cause to indict the petitioner for violation of Section 3E and 3G of Republic Act Number 3019. Moreover, in an addendum to the resolution dated July 10, 2012, then Ombudsman Conchito Carpio Morales held that in addition to the disposition in the resolution dated August 26, 2011, there is also evidence to engender a well-founded belief that the petitioner committed or is probably guilty of the crime of technical malversation, defined and penalized under Article 220 of the Revised Penal Code. She pointed out that the petitioner used the funds specifically appropriated for the site development and housing program in the amount of 50 million pesos, provided under the Appropriation Ordinance number 2007-15, in order to settle the first installment payment of the Balili estate in the amount of 49,849,200, when the said fund was exclusively intended for the acquisition and development of real property for the furtherance of the province's housing program. On July 19, 2012, information charging Garcia, among others, for violation of Sections 3E and 3G of the Public Act number 3019 and Article 220 of the revised penal code were filed before the Sandigan Bayan. Subsequently, on July 24, 2014, the Sandigan Bayan issued three full departure orders against the petitioner and her co-accused. In the meantime, on July 20, 2012, the petitioner, who was based in Cebu, voluntarily surrendered to Judge Soliver C. Peras, first Vice Executive Judge of Cebu City, and made three separate cash deposits of 30,000 pesos as bail for her provisional liberty, corresponding for the three cases filed against her. Accordingly, Judge Paras issued the three separate offense Paras issued three separate orders of release. On September 4, 2012, the petitioner received a HDO along with the three HDOs issued against her. She thereafter filed a motion for consideration with prayer to lift and set aside prematurely issued HDOs, arguing that the HDO cannot be issued without determination of probable cause. She claimed that the HDOs were violative of her constitutional right to travel, which may be impaired only in the interest of national security, public safety, and public health, as may be provided by law. So the relevant issues in this case are whether or not the Sindigan Bayan acted with grade of abuse of discretion amounting to lack or excessive jurisdiction when it issued the HDOs in the absence of any law, governmental regulation, or guidelines authorizing its issuance. The second one is that whether or not the Sandigan Bayan acted with grave abuse of discretion amounting to lack or excessive jurisdiction when it issued the HDOs without sufficient justification for curtailing the constitutionally granted right to travel. The third is whether or not the HDOs were prematurely issued. So, the ruling of the court. As to the first issue, the Supreme Court held that the power to issue HDO is an inherent power belonging to the courts. So, although SC Circular number 3997 admittedly does not mention Office of Ligan Bayan, the rationale of the issuance of the SC Circular number 39-97 was to avoid the indiscriminate issuance of HDOs, resulting in inconvenience to the parties affected, the same being tantamount to infringement of the right and liberty of an individual to travel. It is in view of the perceived unnecessary impairment on the right to travel in certain instances that the guidance for the issuance of HDOs were issued. It bears emphasis that, however, that the circular was not meant to declare the RTC as the sole and exclusive authority in the issuance of HDOs. It only recognizes that the power exists in courts and at the same time seeks to temper its breadth by excluding criminal offenses cognizable by the first level courts. The circular was not meant to exclude all other courts from issuing HDO, but more accurately seeks to make a distinction among the types of criminal offenses by excluding less grave and light offenses from the instances when an HDO may be validly issued. This is to avoid unnecessary restraint on the right to travel, especially in the instances when the gravity of the offense is not serious enough to warrant a restraint or restriction. That the Sandigan Bayan was not mentioned in the circular only means it is given full disposition of all the powers inherent in all courts of justice in order to effectuate the exercise of its jurisdiction, including the issuance of HDOs, if it's in its good judgment it finds necessary in the administration of justice. So as to the second issue, Section 6, Article 3 of the 1987 Constitution states, the liberty of abode and of changing of the same within the limits prescribed by law shall not be impaired except by lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by law. Based on the foregoing, the right to travel may be impaired if necessary in interest of national security, public safety, or public health. Apart from the presence of these exclusive grounds, there is a further requirement that there must be a law authorizing the impairment. The requirement for a law ensures that the necessity for the impairment has undergone a valid and deliberation of Congress before its enactment. The strict requirement for the concurrence of these two elements are formidable enough to serve as safeguards in the full enjoyment of the right to travel. Moreover, although the petitioner may be correct in arguing that there is no law, particularly vesting Sandigan Bayan, the authority to issue HDOs, but this is precisely because the same is not necessary for it to exercise its power. On the other hand, the power to issue HDO is an exercise of court's inherent power to preserve and to maintain the effectiveness of the jurisdiction over the case and the person of the accused. Inherent powers are innate and essential faculties that are fundamental to the constitution of an effective judicial system. They are integral to the creation of courts. They do not require the legislative conferment or constitutional recognition. They coexist with the grant of judicial powers. Inherent powers, in effect, facilitate and reinforce the exercise of the court its specific powers as vital components of jurisdiction. They fortify the court's jurisdiction through processes that ensure its full disposition. And while not enumerated in the Constitution or statute, they are considered part and parcel of the grant of authority to courts. The power to issue full departure order is properly subsumed under the inherent power of the courts because it is an implement by which by which the jurisdiction of the court is preserved. Contrary to the allegation of the petitioner, the issuance of HDO is not a mere practice that is ripened into law or rule. The Sandigan Bayan issues HDO because it has the authority to do so, and this attaches from the moment it acquired jurisdiction over the case and over the person. In this case, jurisdiction over the person was acquired, jurisdiction over the case was acquired when the information against the petitioner were filed with the Sandigan Bayan on July 29, 2012. Thereafter, the petitioner voluntarily submitted herself to the jurisdiction of the court by posting bail at 50,000 pesos for each of the cases filed against her. A court, the implication of posting for bond, as well as was well explained in Manotok versus Court of Appeals. The court said that a court has the power to prohibit a person admitted to bail from leaving the Philippines. This is a necessary consequence of the nature and function of a bail bond. Upon the posting of a bail, the accused subjects himself to the jurisdiction of the court and may validly be restricted in his movement and prohibited from leaving this jurisdiction. He cannot leave the country without the permission of the court, wherein his case is pending. The rule is that a person facing a criminal indictment and provisional release on bail doesn't have unrestricted right to travel. The reason being that a person's right to travel is subject to the usual constraints imposed by the very necessity of safeguarding the system of justice. Moreover, the issuance of the HDO is a process complementary to the granting of bail, since it puts the Bureau of Immigration on notice that a certain person is charged before the courts of law and must not be allowed to leave our jurisdiction without the permission of the court. At any rate, it bears pointing out that notwithstanding the issuance of the HDOs, the petitioner is not absolutely prohibited from leaving the country, as this would place her beyond the reach of our jurisdiction, reach beyond the jurisdiction of our courts, and might render negatory the processes and proceedings being conducted in the cases against her. Nonetheless, she may at any time request for permission to travel abroad, citing grounds for necessity. As to the last issue, the court said that the HDOs were not prematurely issued. While it is the ombudsman who has the full discretion to determine whether or not a criminal case should be filed in Sandigan Bayan, once a case has been filed with the said court, it is the Sandigan Bayan and no longer the ombudsman, which has full control of the case. So much so that the information may not be dismissed without the approval of the said court. Verily, once jurisdiction attaches, it shall not be removed from the court until the termination of the case. So in this case, the Sandigan Bayan acted within its jurisdiction when it issued the HDOs against the petitioner, that the petitioner may seek reconsideration of the finding of probable cause against her by the OMB does not undermine or suspend the jurisdiction already acquired by the Sandigan Bayan. There was also no denial of due process since the petitioner was not precluded from filing a motion for reconsideration of the resolution of the OMB. In addition, the resolution of her motion for reconsideration before the OMB and the conduct of proceedings before the Sandigan Bayan may proceed concurrently. The next case will be Genuino versus De Lima. So the relevant facts are as follows. On May 25, 2010, then acting DOJ Secretary Alberto C. Agra issued the assailed DOJ Circular Number 41, consolidating DOJ Circulars Number 17 and 18, which will govern the issuance and implementation of HDOs, WLOs, and ADOs. After the expiration of GMA's term as the President of the Republic of the Philippines and her subsequent election as Pampanga representatives, criminal complaints were filed against her before the DOJ. In view of the foregoing criminal complaints, De Lima issued the DOJ WLO number 2011-42, dated August 9, 2011, against GMA, pursuant to her authority under DOJ Circular number 41. She also ordered for the inclusion of GMA's name in the Bureau of Immigration watch list. Thereafter, the Bureau of Immigration issued WLO number ASM-11-237, implementing De Lima's order. Meanwhile, on October 2011, uh, the two criminal complaints for electoral sabotage and violation of the OEC were filed against GMA and her husband, Miguel Arroyo. Among others, with the DOJ Commission on Elections Joint Investigation Committee on 2004 and 2007 election fraud. In three separate letters dated October 20, 2011, October 21, 2011, and October 24, 2011, GMA requested for the issuance of an ADO pursuant to Section 7 of DOJ Circular Number 41, so that she may be able to seek medical attention from medical specialists abroad for her hypoparathyroidism and metabolic bone mineral disorder. She mentioned 6 different countries where she intends to undergo consultations and treatments. On November 8, 2011, before resolution of her application for ADO, GMA filed the present petition for certiorari and provision under Rule 65 of the Rules of Court with prayer for the issuance of a TRO and a writ of preliminary injunction, docketed as GR number 199034 to annul and set aside DOJ Circular Number 41 and LLOs issued against her for allegedly being unconstitutional. Also, on November 8, De Lima issued an order denying GMA's application for ADO. At around 8 o'clock p.m. on the same day, the petitioners proceeded to Ninoy Aquino International Airport to take their flights to Singapore. However, the Bureau of Immigration officials at NAIA refused to process their travel documents, which ultimately resulted to them not being able to join their flights. On November 16, 2011, respondents filed a consolidated urgent motion for reconsideration and or to lift TRO. They argued that while petitioners anchored their right in essay on the right to travel under Section 6, Article 3 of the 1987 Constitution, the said right is not absolute. So the issue in this case is whether or not the DOJ Circular Number 41 is unconstitutional for being violative to the constitutional right to travel. So the ruling of the court is that the DOJ Circular Number 41 is unconstitutional and explained that the right to travel is part of the liberty of which a citizen cannot be deprived without due process of law. It is part and parcel of the guarantee of freedom of movement that the Constitution affords its citizens. Liberty under the foregoing clause includes the right to choose one's residence, to leave it whenever he pleases, and to travel wherever he wills. Thus, in citing Zacarias Villavicencio versus Sustolicpan, the court held illegal action of the mayor of Manila in expelling women who were known prostitutes and sending them to Davao in order to eradicate vices and immoral activities proliferated by said subjects. It was held that, regardless of the mayor's laudable intentions, no person may compel another to change his residence without being expressly authorized by law or regulation. It is apparent, however, that the right to travel is not absolute. There are constitutional and statutory and inherent limitations relating the right to travel. Section 6 of the 1987, Section 6 of Article 3 of the 1987 Constitution itself provides that the right to travel may be impaired only in the interest of national security, public safety, or public health, as may be provided by law. Clearly, under the provision, there are only three considerations that may permit a restriction on the right to travel: national security, public safety, or public health. As a further requirement, there must be an explicit provision of statutory law or the rules of court providing for the impairment. The requirement for legislative enactment was purposely added to prevent inordinate restraints on the person's right to travel by administrative officials who may be tempted to wield authority under the guise of national security, public safety, or public health. It is clear from the foregoing that the liberty of abode may only be impaired by a lawful order of the court. On the other hand, the right to travel may only be impaired by a law that concerns national security, public safety, or public health. Therefore, when the exigencies of times call for a limitation on the right to travel, the Congress must respond to the need by explicitly providing for the restriction in the law. So, the court would further that the issuance of DOJ Circular Number 41 has no legal basis. It rationated that there is no law particularly providing for the authority of the Secretary of Justice to curtail the exercise of the right to travel in the interest of national security, public safety, or public health. To be clear, DOJ Circular Number 41 is not a law. It is not a legislative enactment which underwent scrutiny and concurrence of lawmakers and submitted to the President for approval. It is a mere administrative issuance apparently designed to carry out the provisions of an enabling law, which a former DOJ Secretary believed to be EO number 292, otherwise known as the Administrative Code of 1987. Indeed, administrative agencies possess quasi-legislative or rule-making powers, among others. It has the power to make rules and regulations which result in delegated legislation that is within the confines of the granting statute and the doctrine of non-delegability and separability of powers. The exercise of this power, the rules and regulations that administrative agencies promulgate should be within the scope of the statutory authority granted by the legislature to the administrative agency. In the same way, Section 3 of EO 292 does not authorize the DOJ to issue WNOs and HDOs to restrict the constitutional right to travel. There is even no mention of the exigency stated in the Constitution that would justify the impairment. The provision simply grants the DOJ the power to investigate the commission of crimes and prosecute offenders, which are basically the functions of the agency. However, it does not carry with it the power to indiscriminately devise all means it deems proper in performing its functions, without regard to constitutionally protected rights. The curtailment of fundamental right, which is what the OJ Circular Number 41 does, cannot be read into the mentioned provision of the law. Any impairment or restriction in the exercise of a constitutional right must be clear, categorical, and unambiguous. Thus, the question circular does not come under the inherent power of the executive department to adopt rules and regulations. Clearly, the issuance of the AQO and WLO is not the DOJ's business. As such, it is compulsory requirement that there be an existing law, complete and sufficient in itself, conferring the express authority to the concerned agency to promulgate rules on its own. The DOJ cannot make rules its authority being confined to execution of laws without a clear mandate of an existing law. An administrative issuance is ultra vires. Consistent with the foregoing, there must be an enabling law from which the DOJ Circular Number 41 must derive its life. Unfortunately, all of the supposed statutory authorities relied upon the DOJ by the DOJ did not pass the completeness test and sufficient standard test. The DOJ miserably failed to establish the existence of the enabling law that would justify the issuance of question circular. Without a law to justify its action, the issuance of DOJ Circular Number 41 is an unauthorized act of the DOJ of empowering itself under the pretext of dire exigency or urgent necessity. This action runs afoul the separation of powers between the three branches of the government and cannot be upheld. So the exceptions to the right to travel are limited to those stated in Section 6, Article 3 of the Constitution. The DOJ argues that Section 6, Article 3 of the Constitution is not an exclusive enumeration of the instances wherein the right to travel may be validly impaired. It cites that this court has its own administrative issuance restricting travel of its employees, and that even lower courts may issue HDO even on grounds outside of what is stated in the Constitution. It bears reiterating that the power to issue HDO is inherent to the courts. The courts may issue an HDO against an accused in a criminal case so that he may be dealt with in accordance with law. It does not require legislative conferment or constitutional recognition. It coexists with the grant of judicial power. The point is that the DOJ may not justify its imposition of restriction on the right to travel of the subjects of the DOJ Circular Number 41 by resorting to an analogy. Contrary to its claim, it does not have an inherent power to issue HDO, unlike the courts, or to restrict the right to travel in any way. It is limited to the powers expressly granted to it by law, and may not extend the same on its own accord or by any skewed interpretation of its authority.
Good evening, everyone. My name is Christine Bautista, and I will be reporting the last case under freedom of religion and another 4 cases under the right to travel and non-impairment of contracts. So in the case of Macapagal, Arroyo versus De Lima, the consolidated petitions for certiorari and prohibition with prayer for the issuance of temporary restraining orders and or writs of preliminary injunction under Rule 65 of the Rules of Court assail the constitutionality of the Department of Justice Circular Number 41 Series of 2010, or otherwise known as the Consolidated Rules and Regulations governing issuance and implementation of whole departure orders, watchlist orders, and allow departure orders on the ground that it infringes on the constitutional right to travel. The facts of the case are as follows. On March 19, 1998, the DOJ Secretary Silvestre Bello III issued the Circular Number 17 prescribing rules and regulations in the issuance of whole departure orders for the purpose to restrain the indiscriminate issuance of HDOs which impinge on the people's right to travel. After the expiration of GMA's term as the President of the Republic of the Philippines and her subsequent election as the Pampanga representative, criminal complaints were filed against her, particularly plunder, malversation, and illegal use of OWA funds, illegal use of public funds, graft and corruption, and other cases. In view of the foregoing criminal complaints, De Lima issued DOJ Watchlist Order Number 2011-422 against GMA pursuant to her authority under DOJ Circular Number 41. She also ordered for the inclusion of GMA's name in the Bureau of Immigration's watch list. On October 20, 2011, the 2 criminal complaints for electoral sabotage and violation of the OEC were filed against GMA and her husband, Jose Miguel Arroyo. Following the complaints, the spouses Arroyo requested for the issuance of allow departure order to be able to seek medical attention in the country where she intends to seek. She likewise undertook to return to the Philippines once her medical treatment is done to finally face the charges filed against the 2 of them as spouses. However, the petition was subsequently denied. After that, GMA filed a supplemental petition, which included a prayer to annul and set aside the order, which denied her petition of allowed departure order. The court issued a temporary restraining order enjoining the respondents from enforcing and implementing DOJ Circular Number 41 and the watchlist order. On the same day, the petitioners proceeded to Ninoy Aquino International Airport with an aide-de-camp and private nurses. However, the Bureau of Immigration refused to process their travel documents, which resulted to them not to being able to join their flight. Not long after, Miguel Arroyo filed an urgent manifestation, which they anchored their right to travel under Section 6, Article 3 of the 1987 Philippine Constitution. So the issue in this case is whether or not the Department of Justice Circular Number 41 is unconstitutional in violating one's right to travel under the Section 6, Article 3 of the Philippine Constitution. The court ruled in affirmative. The issuance of the DOJ Circular Number 41 has no legal basis. Under Section 6, Article 3 of the 1987 Constitution provides 3 considerations that may permit a restriction on the right to travel. which is the national security, public safety, or public health. As further requirement, there must be an explicit provision of statutory law or the rules of court providing for the impairment. The Supreme Court, in ruling in this case, had to lay down the foundations of right to travel, that the right to travel is part of the liberty of which a citizen cannot be deprived without a due process of law. It is a part and parcel of the guarantee of the freedom of the movement that the Constitution affords its citizen. Pertinently, Section 6 of Article 3 of the Constitution. However, the right to travel is not absolute. These are constitutional, statutory, and inherent limitations regulating the right to travel. Section 6 also provides that the right to travel may be impaired only in the interest of national security, public safety, or public health, as may be provided by law. Clearly, the Constitution has only set 3 considerations that may permit restriction on the right to travel. A further requirement, therefore, needs legislative enactment to prevent inordinate restraints by officials who may be tempted to wield authority under the guise of the national security, public safety, or public health. As a further requirement, there must be an explicit provision of statutory law or the rules of court providing for the impairment. There is no law particularly providing for the authority of the Secretary of Justice to curtail the exercise of the right to travel. To be clear, DOJ Circular Number 41 is not a law. It is not a legislative enactment which underwent the scrutiny and concurrence of lawmakers and submitted to the President for approval, but it is a mere administrative issuance apparently designed to carry out the provisions of an enabling law. The provisions being relied upon the former DOJ Secretary will disclose that they do not particularly vest the DOJ the authority to issue DOJ Circular Number 41, which effectively restricts the right to travel through the issuance of the WLOs and HDOs. The curtailment of fundamental right, which is what DOJ Circular Number 41 does, cannot be read into mentioned provision of the law. In conclusion, DOJ Circular Number 41 does not have an enabling law where it could have derived its authority to interfere with the exercise of the right to travel, and thus the said circular is unconstitutional. So the next cases are under the non-impairment of contract under Article 3, Section 10 of the Philippine Constitution, which provides that no law impairing the obligation of contracts shall be passed. The first case is Oposa versus Factoran, where the principal petitioners here are all minors, duly represented and joined by the respective parents, and pleaded as an additional plaintiff is the Philippine Ecological Network Incorporated, which is a domestic, non-stock, and non-profit corporation organized for the purpose of engaging in concerted action geared for the protection of our environment and natural resources. The original defendant was the Honorable Fulgencio S. Factoran Jr., then Secretary of the Department of Environment and Natural Resources, or the DENR. The complaint was instituted as a taxpayer's class suit and alleges that the plaintiffs are all citizens of the Philippines, taxpayers, and entitled to the full benefit, use, and enjoyment of the natural resources treasure that is the country's virgin tropical forests. The same was filed for themselves and others who are equally concerned about the preservation of said resource, but are so numerous that it is impracticable to bring them all before the court. The minors further asseverate that they represent their generation as well as the generations yet unborn. Consequently, they prayed that judgment be rendered ordering defendant, his agents, representatives, and other persons acting in his behalf to first, cancel all existing timber licensing agreements or TLA in the country. Second is to cease and desist from receiving, accepting, processing, renewing, or approving new timber license agreements, and granting the plaintiffs such other reliefs just and equitable under the premises. They allege that they have a clear and constitutional right to a balanced and healthful ecology and are entitled to protection by the state in its capacity as parents patriae. Furthermore, they claim that the act of the defendant in allowing TLA holders to cut and deforest the remaining forests constitutes a misappropriation and impairment of the natural resources property he holds in trust for the benefit of the plaintiff minors and succeeding generations. So the defendant filed a motion to dismiss the complaint on the following grounds: that the plaintiffs have no cause of action against him, and the issues raised by the plaintiffs is a political questions which properly pertains to the legislative or executive branches of the government and the non-impairment of contract clause found in the Constitution. So the issue in this case is whether or not the petition violates non-impairment clause of contracts. And the court ruled in negative. The court is for the benefit of the plaintiff, minors, and succeeding generations, is likewise of the impression that it cannot, no matter how we stretch for our jurisdiction, grant the reliefs prayed for by the plaintiffs. For to do otherwise would amount to impairment of contracts, abhorred by the fundamental law. All licenses may thus be revoked or rescinded by executive action. It is not a contract, property, or a property right protested by the Due Process Clause of the Constitution. In Tan versus Director of Forestry, the court held that a timber license is an instrument by which the state regulates the utilization and disposition of forest resources to the end that public welfare is promoted. A timber license is not a contract within the purview of the Due Process Clause. It is only a license or privilege which can be validly withdrawn whenever dictated by the public interest or public welfare, as in this case. Another jurisprudence also provides that a license is merely a permit or privilege to do what otherwise would be unlawful and is not a contract between the authority, federal, state, or municipal, granting it and the person to whom it is granted. Neither is it property or a property right, nor does it create a vested right, nor is it taxation. Thus, this court held that the granting of license does not create irrevocable rights, neither is it property or property rights. It was also reiterated in Felipe Ismael Jr. versus Deputy Executive Secretary that timber license, permits, and license agreements are the principal instruments by which the state regulates the utilization and disposition of forest resources to the end that public welfare is promoted. They may validly amended, modified, replaced, or rescinded by the chief executive when national interests so require. Thus, they are not deemed contracts within the purview of the Due Process of Clause. In the second place, even if it is to be assumed that the same are contracts, the instant case does not involve a law or even an executive issuance declaring the cancellation or modification of existing timber licenses. Hence, the non-impairment clause cannot as yet be invoked. Nevertheless, granting further that a law has actually been passed mandating cancellations or modifications, the same cannot still be stigmatized as a violation of non-impairment clause. This is because by its very nature and purpose, such as law could have only been passed in the exercise of the police power of the state for the purpose of advancing the right of the people to a balanced and healthful ecology, promoting their health and enhancing the general welfare. In Abe versus Foster Wheeler Corp., this court stated that the freedom of contract under our system of government is not meant to be absolute. In other words, the constitutional guarantee of non-impairment of obligations of contract is limited by the exercise of the police power of the state in the interest of public health, safety, moral, and general welfare. In short, the non-impairment clause must yield to the police power of the state. The last case under the topic of non-impairment of contract is LBP versus Republic. The facts of the case are as follows. A lot was issued in favor of Angelito C. Bugayong and was divided into 4 lots that were approved by the Commissioner of Land Registration. Thereafter, the lot was cancelled and was replaced with new transfer certificates of titles in favor of the same person. The 4 lots were sold to different persons, and the first one was sold to spouses Lourdes and Candido Du. And accordingly, the said TCT was cancelled and was replaced again in the name of the title of the spouses. The spouses caused the subdivision of the land to where it became 2 lots and were sold to spouses Felix and Guadalupe Dayola. The other remaining lot was retained and registered under their names. Again, the TCT was cancelled and was replaced by another registered in the name of Lourdes Farms, Inc., to where they mortgaged the sales patent in favor of Bugayong was improperly and illegally issued, and that the Director of Lands had no jurisdiction to dispose of the subject land. The Republic of the Philippines instituted a complaint for the cancellation of the title patent and reversion of the land into the mass of public domain. The complaint was filed against Bugayong and other present owners and mortgagees of the land, such as Lourdes Farms, Inc. and the latter's mortgagee petitioner, LBP. The RTC rendered its judgment on July 9, 1996, determining that it is clear that the mother title in the name of defendant Bugayong was issued at the time when the area was not yet released by the Bureau of Forestry to the Bureau of Lands. The RTC explained that the titles issued to private parties by the Bureau of Lands are void ab initio if the land covered by it is a forest land, and it went further by stating that if the mother title is void, all titles arising from the mother title are also void. So the Court of Appeals ruled against the appellants. And the issue in this case is whether or not there was impairment of contract. And the court ruled in negative. There was no impairment of contract but a valid exercise of police power of the state. The constitutional guarantee of non-impairment of contracts may not likewise be used by LBP to validate its interest over the land as mortgagee. The state's restraint upon the right to have an interest or ownership over the forest lands does not violate the constitutional guarantee of non-impairment of contracts. Said restraint is a valid exercise of the police power of the state. As explained by the court in Director of Forestry versus Munoz, the court takes of the cases at bar is but in adherence to public policy that should be followed with respect to forest lands. Because of the importance of forests to the nation, the state's police power has been wielded to regulate the use and occupancy of forests and the forest reserves. In Edu versus Ericta case, the court defined police power as the authority of the state to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. As long as the activity or the property has some relevance to the public welfare, its regulation under the police power is not only proper but necessary. Preservation of our forest lands could entail intrusion upon contractual rights, as in this case, but it is justified by the Latin maxims salus populi est suprema lex and sic utere tuo ut alienum non ledas, which call for the subordination of individual interests to the benefit of the greater number. The next topic would be rights under investigation under Article 3, Section 12 of the 1987 Constitution. The first case is Yap versus People, and the facts of the case are as follows. Johnny Garcia Yap was charged with the crime of attempted murder. Petitioners said that they were in a car supposedly to meet some girls they previously dated, but Ang was not happy with the arrangement, which led to an argument between the two. Ang then punched Yap's face, causing the latter to retaliate. Respondent contends that Yap gave him a coffee, which led to be drowsy. In both statements, the result ended with Ang having a bloody forehead after being hit with a bat and was able to escape and ask help from passersby. The accused was charged with the crime of attempted murder as he willfully, unlawfully, and feloniously intended to kill, with treachery and evident premeditation, the victim. The accused also said that he performed all the acts of execution which would produce the crime of murder as a consequence, but by reason of self-defense during retaliation and scuffling event between him and the victim. He further said he was able to wrest possession of the rolling pin and was able to hit victim's forehead, causing wound and bleeding. So the issue in this case is whether or not Yap was bound by his previous counsel's gross mistake in invoking self-defense, as the latter did not explain the nature and concept of such defense. The court ruled in affirmative. It is well settled rule that the client is bound by the counsel's conduct, negligence, and mistakes in handling the case, and the client cannot be heard to complain that the result might have been different had his lawyer proceeded differently. An exception to this rule is consistently enunciated in a number of cases, and that is when the negligence of counsel had been so egregious that it prejudiced his client's interest and denied him his day in a court. In the case at bar, the general rule applies, and the above exception finds no application because the petitioner failed to prove that his previous counsel's act of invoking self-defense on petitioner's behalf is tantamount to gross negligence as to deprive petitioner of his right to due process. The court agrees with the Office of the Solicitor General that records would show that petitioner was ably represented by his former counsel during trial and was not denied the due process, as shown by the following. That first, Petitioner and his wife were able to take the witness stand where they themselves were personally able to present their case to the court during the direct examination. Second, that during cross-examination, petitioner was able knowingly and intelligently answer the questions propounded to him by the prosecutor and the trial judge. And lastly, when the prosecution presented its case, petitioner, through his former counsel, was able to examine the witnesses and the evidence presented. It is true that the right to be assisted by counsel is an indispensable component of due process in criminal prosecution, and that such right is one of the most sacrosanct rights available to the accused. Moreover, for the above-mentioned exception to apply, the gross negligence of counsel should not be accompanied by his client's own negligence or malice. In this regard, the court likewise agrees with the OSG's observations and accompanying argument that petitioner was guilty of negligence for his failure to raise the issue of his former counsel's alleged incompetence before the trial court and the Court of Appeals after engaging the services of a new counsel. It appears that his defense is merely afterthought because if petitioner and his present counsel really believed that the previous counsel was guilty of gross incompetence in handling petitioner's case, they would have brought this matter to the attention of either the RTC or the CA at the first instance, but they did not. Hence, they must suffer the effect of their passivity and inaction. The RTC also observed that petitioner never mentioned during the police investigation that he acted in self-defense. The issuance of credibility, when it is decisive of the guilt or innocence of the accused, is determined by the conformity of the conflicting claims and recollections of the witnesses to common experience and to the observation of mankind as probable under circumstances. It has been appropriately emphasized that the court has no test of the truth of the human testimony except its conformity in human knowledge, observation, and experience. Whatever is repugnant to this belongs to the miraculous and outside of the judicial cognizance. In sum, the court finds no error in the decision of both the RTC and the CA that petitioner's assertion of self-defense cannot be justifiably appreciated for being uncorroborated by independent and competent evidence and for being extremely doubtful by itself. So the last case is People versus Moreno, and the facts of the case are as follows. That on November 16, 2001, Riza and her husband Cecil were sleeping in their house in Manila. Riza woke up when something hit her head, switching on the light, and she saw a man in khaki shorts and white t-shirt stabbing Cecil, and the man fled. She shouted for help. The neighbors came and they brought Cecil to the hospital. However, he died. Riza did not know how the killer was, but she was only remembered his face. Our cartographer drew a sketch of the killer's face. On a tip, the police arrested Moreno around noontime, and Riza identified him as the killer. Moreno denied the accusation. His mother and brother corroborated his story. He said that while he was sleeping, a robbery occurred nearby. He went out wearing black pants and a gray t-shirt. A neighbor asked him to get a taxi, and then he helped carry Cecil inside it. Afterwards, he went back to sleep. At around 11 a.m. of the same day, the police invited him to the station where Riza identified him as the killer. An information for murder was filed against Moreno, who entered the plea of not guilty. And after the due trial, the RTC found him guilty of murder. The court held that the clear, positive, and credible testimony of Riza that Moreno was the culprit sufficiently removed any reasonable doubt on his guilt. It rejected his defenses of alibi and denial. On appeal, the Court of Appeals upheld the trial court's decision. Thus, Moreno appealed to the Supreme Court. The court explained that denial is inherently a weak defense which cannot outweigh positive testimony. A categorical statement that has been earmarked of truth prevails over a bare denial, which can easily be fabricated and is inherently unreliable. For the defense of alibi to prosper, the accused must prove that he was at some other place at the time of the commission of the crime, and that it was physically impossible for him to be at the locus delicti or its immediate vicinity. These requirements of the time and place must be strictly met. The appellant Moreno said that he was asleep when the attack occurred. He said he never met Cecil and saw him for the first time when he helped put him into a taxi. But he admitted that only a wall separated his house from that of Cecil and Riza's. The appellant likewise questions the legality of his identification and arrest and the conduct of custodial investigation. He alleged that the procedure was irregular and that he was deprived of his constitutional right to have a counsel present. So the issue in this case is whether or not the arrest of appellant and conduct of custodial investigation was proper. And the court ruled in negative. The Supreme Court ruled and illustrated that the positive, categorical, consistent identification of a single witness prevails over the alibi and denial of the accused. He alleges that, contrary to the conclusion of the trial court, his defense was not all an alibi to account his whereabouts. Rather, it was an attestation of his plain denial of the crime charged. The court ruled in People versus Colais and Sampson that appellant is now stopped from questioning any defect in the manner of his arrest as he failed to move for the quashing of the information before the trial court. Consequently, any irregularity attendant to his arrest was cured when he voluntarily submitted himself to the jurisdiction of the trial court by entering a plea of not guilty and by participating in the trial. There was no violation of appellant's right to counsel during custodial investigation. The records show that appellant was informed of his constitutional rights when he was arrested, and since he chose to remain silent, he was not interrogated and no statement or evidence was extracted from him. Neither was any evidence presented in court that was supposedly obtained from him during custodial investigation.
In Porteria versus People, Christian here is the registered owner of a blue Honda motorcycle and he parked it in front of the hospital where he does his shift. After his shift, he was unable to find his motorcycle and he went to PNP Naga City Police Office Precinct Number 2 to report that it was stolen. The next day, Christian and his brother went to the Highway Patrol Group and he was asked then to submit the original copies of the ORCR of his motorcycle. Thereafter, the police officers of Ocampo supposedly received a report that there was a suspicious person with something tucked in his waist, and the report eventually resulted in the arrest of Marvin Manebali, here in petitioner, for the illegal possession of firearm. Marvin was also subjected to search of his body and bag and allegedly found in possession an assortment of documents, including the photocopies of OR and CR of Christian's stolen motorcycle. After learning of the incident, Virgie, the mother of Christian, went to Naga City District Jail, and Marvin apparently confessed his guilt, and Virgie testified that Marvin admitted that he left the motorcycle with a certain instant joy. Thereafter, the police notified Christian regarding the recovery of a blue motorcycle in Barangay Kaingin, Santa Rosa, Laguna that was flagged down because the driver who admitted that he was not the owner of such was not wearing any helmet. So Marvin then denied the accusations of the prosecution. He alleged that at the time of the incident, his friend Francis was the one who was driving the motorcycle and left the bag on top of it. Francis then left the area and the police officers approached him and invited him to go to the police station. Marvin refused, but the police officers forced him to go with them. They brought him to the Ocampo police station where he was interrogated and detained. At no point here was Marvin informed of his rights when the police officers told him about a gun recovered inside his bag. Marvin then denied owning the bag, much less its contents. So an information was then filed against Marvin for violation of RA number 6539. The trial court then failed to obtain jurisdiction over Albert and Felix, but it rendered the judgment finding Marvin guilty beyond reasonable doubt based on the circumstantial evidence presented. Marvin then filed a notice of appeal and the RTC allowed the appeal and elevated the records of the case to the CA. The CA then denied the appeal, further stating that the extrajudicial confession Marvin made to Virgie also corroborated the evidence of the prosecution. Marvin's motion for reconsideration was denied. Hence, Marvin filed his present petition for review on certiorari under Rule 45. So the issue here in this case is whether or not the extrajudicial confession was sufficient to prove Marvin's guilt. The court here held no, since Marvin's alleged admissions of guilt do not suffice to convict him for carnapping. It also stated here that it also stated here It also stated here that Section 12 of Article 3 of the 1987 Constitution states that persons under investigation for the commission of an offense should be informed of their right to remain silent and the right to counsel. These rights may not be waived except in writing and in the presence of a counsel. Any confession or admission obtained in violation of this provision is inadmissible as evidence against the accused. Section 2D of RA 7438 further states that any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel or in the latter's absence upon a valid waiver and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest, or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. These safeguards are meant to insulate the accused from coercive psychological, if not physical, atmosphere of a custodial investigation. As to Porteria's supposed admission to Police Inspector Villamer that the motorcycle is in the possession of a certain Felix, Porteria was not informed of his custodial rights when he was arrested. When the police officers began questioning Marvin about the items found in his possession, there should have been a counsel present to assist him. Without the assistance of a counsel and in the absence of a valid waiver of this right, Porteria's voluntary answer to Police Inspector Villamer is inadmissible as evidence of his guilt. Moreover, as to the supposed confession to his mother, it is not within the scope of the constitutional and statutory limitations of extrajudicial confessions. However, the prosecution must establish that the accused spoke freely without inducement of any kind and fully aware of the consequences of the confession. This may be inferred from the language of the confession as when the accused provided details known only to him or her. So the court cannot determine now the voluntariness of said confession because it was not reduced into writing or recorded in any other manner. Nonetheless, such may be admitted as an independently relevant statement, but does not necessarily mean that the court is persuaded. So the only remaining circumstance here is the recovery of the stolen motorcycle. The driver of the stolen motorcycle was Albert and not the petitioner in this case. So Marvin was not even present at the time Albert was driving the motorcycle. Let's go now to the right to bail. So in the case of Extra Excel International Philippines Inc. versus Honorable Kajihal. So this is an administrative complaint relative to criminal case for qualified theft filed by Extra Excel International Philippines Inc., represented by Attorney Oliva against Ika Katipunan, who was a former inventory control service assistant with respondent Judge Kajihal of Branch 96 of the RTC of Quezon City as the presiding judge. So in this case, Extra Excel alleged that Judge Kajihal committed the following acts among others. First, when he eventually arraigned the accused, instead of ordering the accused's commitment and despite the offense being non-bailable, he allowed the accused to go home. Second, during the bail hearing, the judge found the filing premature and issued a warrant of arrest against accused. However, instead of committing the accused to the Quezon City Jail, he was instead detained at the Criminal Investigation and Detention Unit of Central Police District, Camp Caringal, Quezon City. Third, thereafter, respondent judge scheduled the bail hearing despite manifestation by complainant's counsel of his unavailability during the said date. And lastly, during the bail hearing, the judge declared the petition for bail submitted for resolution due to the absence of complainant's counsel. And even on the said date, judge issued an order granting the bail petition and denying the motion for inhibition. So based on the foregoing events, Extra Excel alleged that it clearly showed that Judge Kajihal was guilty of the grave abuse of authority when he allowed the accused to go home after his arraignment for a non-bailable offense and of gross ignorance of the law and evident partiality in granting the petition for bail despite the complainant's pending motion for reconsideration and or motion to set the hearing for another date. So the judge here countered that with regard to his alleged failure to order the commitment of the accused after his arraignment and allowing him instead to go home, he explained that there was yet no warrant issued for the arrest of the accused. Moreover, a petition for bail had been filed, hence there was no reason to detain the accused. With respect to the order granting bail to the accused, the judge claimed that the same was not at all objected by the public prosecutor during trial. So the office of the court administrator then held that Judge Kajihal was indeed administratively liable, but did not err in allowing the accused to go home after his arraignment without bail. So the pertinent issue in this case is the respondent judge guilty of gross ignorance of the law. So the court here held yes. However, the court does not concur with the evaluation of the OCA that respondent judge did not err in allowing the accused to go home after his arraignment. The court also said that it was neither persuaded by respondent judge's claim that there was no reason for him to detain the accused since there was yet no warrant issued for his arrest or that a petition for bail had been filed. Basic is the principle that upon setting a case for arraignment, the accused must have either been in the custody of the law or out on bail. Another basic principle we must remember is that the judge must conduct his own personal evaluation of the facts and circumstances which gave rise to the indictment pursuant to Section 5, Rule 112 of the Rules of Court and Section 2, Article 3 of the 1987 Constitution. Indeed, in the present case, the judge should not have waited for the accused to file an omnibus motion for a judicial determination of probable cause. Also, the court mentioned the case of Leviste versus Alameda, which it stated there that the court to conduct a judicial determination of probable cause is a mere superfluity, for with or without such motion, the judge is duty bound to personally evaluate the resolution of the public prosecutor and the supporting evidence. Thus, the failure of respondent judge to comply with his fundamental precept constituted gross ignorance of the law and procedure. His failure to heed this precept resulted in the said accused's arraignment without the accused in custody of the law. In addition, the judge's failure to conduct a hearing on the accused petition for bail likewise constitutes gross ignorance of the law. It is axiomatic that a bail hearing is a must, despite the prosecution's lack of objection to the same. The court here also mentioned Balanay versus Judge White. It said that it is basic, however, that bail hearing is necessary even if the prosecution does not interpose any objection or leaves the application for bail to the sound discretion of the court. Also, the court mentioned the case Villanueva versus Judge Buaya, wherein the court has always stressed the indispensable nature of a bail hearing in petitions for bail. Where bail is a matter of discretion, the grant or denial of bail hinges on the issue of whether or not the evidence of guilt of the accused is strong, and the determination of whether or not the evidence is strong is a matter of judicial discretion, which remains with the judge. So, in order for the judge to properly exercise this discretion, he must first conduct a hearing to determine whether the evidence of guilt is strong. This discretion lies not in the determination of whether or not a hearing should be held, but in the appreciation and evaluation of the weight of the prosecution's evidence of guilt against the accused. In any event, whether bail is a matter of right or discretion, a hearing for a petition of bail is required in order for the court to consider the guidelines in fixing the amount for bail. So, the court also repeatedly held in past cases that even if the prosecution fails to adduce evidence in opposition to an application for bail of an accused, the court may still require the prosecution to answer questions in order to ascertain not only the strength of the state's evidence, but also the adequacy of the amount of bail. Hence, it is altogether of no consequence that the order granting bail was made in the presence of the public prosecutor, and the latter made no objection or comment in the oral manifestation of the defense counsel. In sum, the court found the responded judge guilty of of gross ignorance of the law and procedure in failing to make a judicial determination of probable cause and in failing to conduct a hearing on the accused application for bail. Let's go now to rights of the accused. So in the case of Commodore Lamberto Torres versus Sandigan Bayan, from 1991 to 1993, Commodore Lamberto R. Torres, or Torres, here in petitioner, was the Assistant Chief of the Naval Staff for Logistics under the Flag Officer in Command of the Philippine Navy. The Commission of Audit then conducted a special audit pertaining to the procurement of drugs and medicines by emergency mode purchase, among others, and uncovered an alleged overpricing of medicines. So the Ombudsman then commenced a preliminary investigation against Torres and several others for illegal use of public funds and violation of Section 3E of the Anti-Graft and Corrupt Practices Act. Torres was then included, being the signatory of the checks involved, and because he allegedly recommended the approval of the purchase orders and signed the certificates of emergency purchases. However, these cases were dismissed against Torres for lack of probable cause. A few years later, after Torres's retirement from service, the Tanod Bayan Marcelo issued an internal memorandum recommending a new fact-finding investigation and preliminary investigation relative to other transactions in other units and offices of the Philippine Navy. Hence, a new affidavit complaint was filed by the Ombudsman against Torres and several others. Notices were, however, sent to Torres's old address, which he had already vacated. Thus, Torres was not informed of the 8 informations that were filed by the Ombudsman against him and the other accused before the Sandigan Bayan. It was only sometime in 2014 when Torres was about to travel to the United States that he learned of the pending cases by virtue of a whole departure order against him. Torres was thereafter allowed to file a counter affidavit before the office of the Ombudsman, where he prayed for the dismissal of the case on the ground that his constitutional right to a speedy trial was violated by the inordinate delay of the case. The Ombudsman resolved to maintain the informations filed against Torres. Aggrieved, Torres filed a motion to quash the informations before the Sandigan Bayan, arguing that the Ombudsman had no authority to file having conducted the fact-finding and preliminary investigation for too long, or for about 18 years. Sandigan Bayan then denied Torres's motion to quash and likewise denied his motion for reconsideration. Hence, this present petition for certiorari under Rule 65 seeking the annulment of the Sandigan Bayan resolution. So the issue here is whether or not Torres's right to the speedy disposition of his cases was violated. So the court here held yes, the right to a speedy disposition of a case is deemed violated only when the proceedings are attended by vexatious, capricious, and oppressive delays, or when unjustified postponements of the trial are asked for and secured, or when without cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. So the court here finds it necessary to emphasize that the speedy disposition of case covers not only the period within which the preliminary investigation was conducted, but also all stages to which the accused is subjected, even including the fact-finding investigations conducted prior to the preliminary investigation proper. So the court here explained in Danzal versus Fernandez Sr. That it was initially embodied in Section 16, Article 4 of the 1973 Constitution, that the constitutional provision is one of the three provisions mandating speedier dispensation of justice. So it guarantees the right of all persons to a speedy disposition of their case. So it includes within its contemplation the periods before, during, and after trial, and affords a broader protection than Section 14(2), which guarantees just the right to a speedy trial. So it is more embracing than the protection under Article 7, Section 15, which covers only the period after the submission of the case. So the present constitutional provision applies to civil, criminal, and administrative cases. So the court here also said that any delay in the investigation of and prosecution of cases must be duly justified. The state must prove that the delay in the prosecution was reasonable or the delay was not attributable to it. Here, the lapse of time in the conduct of the proceedings this was proven to be tantamount to a vexatious, capricious, and oppressive delay, and Torres has undoubtedly been prejudiced by virtue of the delay in the resolution of the cases filed against him. So even though he was not initially included as a respondent in the investigation conducted from 1996 to 2006 pertaining to the overpricing of medicines, he has already been deprived of the ability to adequately prepare his case, considering that he may no longer have any access to such records or contact with any witness in support of his defense. This was even aggravated by the fact that Torres had been retired for 15 years. So even if he was never imprisoned and subjected to trial, it cannot be denied that he has lived under a cloud of anxiety by virtue of the delay in the resolution of his case. Go now to Villa versus Fernandez et al. So this case stemmed from the death of Leonardo Lenny H. Villa, a neophyte participant at the initiation rites of the Aquila Legis Fraternity in 1991. So because of his death, an amended information charging 35 members of the Aquila with the crime of homicide was filed. So out of the 35 members, 26 members were charged with homicide in criminal case number C3834091, while 9 members were charged with homicide in criminal case number C38340. So the 26 members were jointly tried, while the trial against the remaining 9 members was held in abeyance. So the Regional Trial Court of Branch 130 denied the motions filed by Ampil and Cabangon here in respondents. However, the Court of Appeals granted the appeal of the other members and dismissed the case, finding that the right to speedy trial was violated. So this then prompted respondents Fernandez, Ampil, and Cabangon to file a joint motion to dismiss, alleging that first, their constitutional right to speedy trial was violated because the suit was pending for more than 15 years, and the CA's decision dismissing the case against the other members should also apply to them because they are similarly situated, and their participation in the initial stages of the trial did not preclude the filing of a motion to dismiss on the ground of the violation of their right to speedy trial. So the RTC then denied the motion to dismiss and explained the slow progress of the case. It likewise denied their motion for partial reconsideration. So the CA then reversed the findings, applying the principle of equal protection of the law. The CA then denied Villa's motion for reconsideration, hence this present petition for review on certiorari. So the issue here is whether or not the Court of Appeals committed grave, serious, and irreversible errors in finding that the delay in the proceedings in criminal case number 38340 is of such nature that violates the right of the respondents to speedy trial. So the court here held no. An accused's right to have a speedy, impartial, and public trial is guaranteed in criminal cases by Section 14.2 of Article 3 of the 1987 Constitution. It is its salutary objective being to assure that an innocent person may be free from the anxiety and expense of court litigation, or if otherwise, of having his or her guilt determined within the shortest possible time, compatible with the presentation and consideration of whatsoever legitimate defense he or she may um, interpose. Thus, the right to speedy trial is deemed violated when the proceeding is attended by vexatious, capricious, and oppressive delays, or when unjustified postponements of the trial are asked for and secured, or when without cause or justifiable motive, a long period of time is allowed to elapse without the party having one's case tried. So, equally applicable here in this case is the balancing test. The balancing test here is used to determine whether a person has been denied the right to speedy trial, in which the conduct of both the prosecution and the defendant is weighed. And such factors as length of delay, reason for delay, the assertion or non-assertion of the right, and prejudice resulting from the delay are considered. In the present petition, Villa insists that the right to speedy trial of Fernandez, Ampel, and Cabangon was not violated because the reasons for the delay were attributable to them, and they failed to timely invoke their right. In the Villarreal case. So, contrary to Villa's assertions, the CA's ruling, as supported by the records, reveals that the following circumstances delayed the proceedings against Fernandez, Ampel, and Cabangon. So first, the prosecution failed to comply with the order of the RTC Branch 130, requiring it to secure the records from the CA. Second, the initial trial of the case more than commenced only after 11 years later. And then the RTC Branch 130 resolved Pill's motion to quash and Fernandez's omnibus motion more than 10 years after the motions were filed. And the RTC Branch 130 then resolved Fernandez, Ampil, and Cabangon's joint motion to dismiss for more than 5 years after said motion was filed. So moreover, RTC Branch 130 in its order also stated the reasons of the delay of the proceedings before it, such as first the dismissal from the service of Judge Hamoy, second Judge Sardillo's heavy workload, third the CA's order restraining the proceeding of the case, and fourth the motion for transfer of trial venue and the motion for inhibition filed by the prosecution. Clearly, the reasons for the delay of the proceedings against the respondents are not attributable to them. Moreover, the reasons for the delay in the proceedings in Villarreal are similar to the reasons for the delay in the proceedings against the respondents. So in Real, the court held that the prosecution's failure to comply with the orders of the trial court and the inaction of the trial court for almost 7 years amount to a violation of the right to speedy trial of Ramos, Saruca, Escalona, and Adriano, the other members who were also alleged to have committed the crime. So in this case, not only were the reasons for the delay in the proceedings against the other members were present as to the respondents, but also a more unjustifiable circumstance added delay to the proceedings against the respondents, such as again the RTC's delayed resolution of the motions to quash and motion to dismiss. Thus, there is more reason to apply the ruling in Villarreal to Fernandez, Ampil, and Cabangon here in respondents and find that the right to speedy trial has been violated. The court here also said that contrary to Villa's contention that the respondents failed to invoke their right, the court here mentioned in Almeda versus Office of the Ombudsman, the petition, it held that the petitioner's letter and manifestation seeking the immediate resolution of the case cannot be considered late, and no waiver of her right to speedy trial or acquiescence may be attached to the same, as she was not, again, required as a rule to follow up her case. Instead, we must remember that it is the state's duty to expedite the same. Similarly, in this case, we find that Fernandez, Ampil, and Cabangon timely invoked and did not waive their right to speedy trial.
Good evening, attorney. Good evening, classmates. I'm Lyndon Aliana Valenzuela, and I'll be reporting the last four cases for Group 6. So this case is still under the rights of the accused, specifically the right to speedy disposition of cases. Sorry. So the facts of the case in Kagang versus SB. So this involves two consolidated petitions questioning the denial of the Sandigan Bayan to quash the information in order of arrest against Kagang. So the information filed against him was about malversation of funds. So the criminal complaint was filed February 10, 2003. On August 11, 2004, the Office of Ombudsman issued a resolution finding probable cause against the petitioner. This was modified um, by the resolution dated October 18, 2004, which further ordered a fact-finding investigation. The fact-finding was resolved only April 12, 2005. And then August 8, 2011, or 6 years after the recommendation, um, then it was only then that informations were officially filed against Kagang, and an order of arrest was ordered against him. So he was assailing that there was an ordinate delay of 7 years in filing of the informations. He also cited the cases Tatad versus Sandigan Bayan and Roque versus Ombudsman, and argued that the delay violated his rights to due process and speedy disposition of cases. So that there are two issues here. Number one is whether or not the respondent committed inordinate delay in the termination of the preliminary investigation against petitioner, and whether or not the accused's rights to speedy disposition of cases was violated. So before we delve further into the ruling, I would first like to show you the doctrine. So as provided in the case, inordinate delay in the resolution and termination of a preliminary investigation violates the accused's right to due process and the speedy disposition of cases, and may result in the dismissal of the case against the accused. The burden of proving delay depends on whether delay is alleged within the periods provided by law or procedural rules. So if the delay is alleged to have occurred during the given periods as provided by law or other procedural rules like the rules of court, the burden will be on the respondent or the accused to prove that delay was inordinate. However, if the delay is alleged to have occurred beyond the given periods, the burden will now shift to the prosecution, and they will now have to justify why there was a delay, and they must be able to show that there was no prejudice suffered by the accused. So the determination of whether the delay was inordinate is not through a mere mathematical reckoning, but through the examination of facts and circumstances surrounding the case. Courts should appraise a reasonable period from the point of view of how much time a competent and independent public officer would need in relation to the complexity of a given case. So it was saying here that the delay is not just about the number of days that are followed, or whether or not they were followed as provided by law or the rules of court. It was actually about the complexity or the totality of the circumstances of the case. So the courts will not only look into the number of days leading to the delay or that led to the delay, but they will also look into the reasons or the peculiar circumstances of the case, or whether or not it is a complex case. So if there has been a delay, the prosecution must be able to satisfactorily explain the reasons for such delay and that no prejudice was suffered by the accused. Also, it is important that there is a timely invocation of the accused's constitutional rights, or else it would constitute as a valid waiver of such right. So to answer the issues, yes, there was a delay on the part of the respondent. So the court ruled that 6 years is beyond reasonable period of fact-finding of 90 days. So the burden of proving the justification for delay was now shifted to the prosecution. The prosecution, as a defense, said that the delay was justified since it was still determining whether accused Gadian and could be utilized as a state witness, and it still had to verify the accused Felipe Constantino's death. Okay, but upon delving into the records, the court found that the recommendation to utilize Gadian as a state witness was approved back in 2004. Felipe's death was verified or confirmed in 2006. Therefore, there is delay from November 14, 2006 to August 8, 2000. Yes, there was a delay on the part of the respondent. So the court ruled that 6 years is beyond reasonable period of fact-finding of 90 days. So the burden of proving the justification for this 2011. For the second issue, the court ruled that no, the right to a speedy disposition of cases by petitioner was not violated for his failure to invoke the same. So the court found herein that petitioner only invoked his right to speedy disposition of cases when the informations were filed on November 17, 2011. So as provided in jurisprudence, waiver of right does not necessarily require that the respondent has already suffered the rigors of criminal prosecution. The failure of the respondent to invoke the right even when or during the time he has suffered or will suffer the consequences um, is a valid waiver of such right. So the records of the case show that the transactions investigated are complex and numerous, and the accused knew that the case was complex since uh, there were over 100 individuals that were investigated. 40 of them have been involved in 81 different anomalous transactions. However, still, even though there was a big lapse of time already during the preliminary investigation, Kagang only invoked such right at the end or during the filing of the or after the filing of the information. So the court ruled herein that there was a valid waiver of the right to speedy disposition of cases already. Okay, so there in the case of Kagang, this was provided. So this is a mode of analysis in situations where the right to speedy disposition of cases or right to speedy trial is invoked. So it's a mode of analysis and it can help us ascertain whether or not the constitutional right is violated or not. So number one, the right to speedy disposition of cases is different from a right to speedy trial. So a right to a speedy trial may only be invoked in criminal prosecutions, while right to speedy disposition of cases may be invoked in a tribunal or before any tribunal, whether judicial or quasi-judicial. A case is deemed initiated upon the filing of formal complaint prior to a conduct of preliminary investigation. So the period taken for a fact-finding investigation prior to the filing of formal complaint shall not be included in determination whether or not there has been an inordinate delay. Third, courts must determine which party carries the burden of proof. So again, you will look into if the delay was during the time provided by the law or procedural rules or beyond that. So if it is within still of the period provided by the law or the rules, then the defense has the right. The defense has the burden of proving that the right was justifiably invoked. If the delay occurs beyond, then the prosecution now has to justify the delay. Next is determination of the length of delay is never mechanical. So as I have mentioned, it is not about the number of days or leading to such delay. So the courts must consider the entire context of the case from the amount of evidence to be weighed to the simplicity or complexity of the issues raised. But there are two exceptions in the length of the delay is never mechanical. So number one is if malicious prosecution is properly alleged and substantially proven, the case will be automatically dismissed. Number two is the waiver of the accused to the right to speedy disposition of cases or the right to speedy trial. If it can be proven that the accused acquiesces to the delay, the constitutional right can no longer be invoked. Last is the right to speedy disposition of cases or the right to speedy trial must be timely raised. So the respondent or the accused must file the appropriate motion upon the lapse of the statutory or procedural periods. Otherwise, they are deemed to have waived the right to speedy disposition of cases. Okay. So next case is People versus Rodriguez. So the right of the accused that will be tackled here is the right to confront the witnesses against the accused. So what happened here was that Benson Evangelista, who was a car salesman, was abducted by a group of men, and his charred remains were later found in Nueva Ecija. So the imputed criminals or culprits were the respondents. Mendiola and Parulan voluntarily surrendered to the PNP and executed extrajudicial confessions identifying the Dominguez brothers as the masterminds of the crime. So later, an information was filed with the RTC. The prosecution presented a motion to make Mendiola as a state witness. This was granted. On said date, Mendiola gave his testimony and was cross-examined by the counsel for the defense. Nevertheless, the defense manifested that the cross-examination was limited only to the incident of discharge and that their party reserved the right to a more lengthy cross-examination during the presentation of the evidence in chief. However, on May 6, 2012, Mendiola was founded. Later, the RTC and CA ruled that the testimony of Mendiola will be stricken out of the evidence of the criminal case, and it was consented, or the accused said that if they were to not have stricken out the the testimony of Mendiola, it would be violative of their right to confront the witnesses against them. So the issue of the case is whether or not the testimony of Mendiola should be stricken off, and whether or not the non-stricken of Mendiola's testimony would violate the right to confront witnesses of the accused. The court ruled that no, Mendiola's testimony shall not be stricken off. So as provided in the case of People versus Series, the testimony of the deceased prosecution witness shall not be expunged from the records if the defense was able to conduct a rigorous and extensive cross-examination prior to the demise. Such also cover the details of the commission of the offense. Here, it was seen that there was in fact a cross-examination cross-examination of Mendiola by the counsel of the defense. So they were able to actually exercise such right. Now, whether or not the non-stricken of the testimony is violative of the accused's rights to confront and cross-examine the witness, and the court ruled that no, it did not violate because again, they already exercised such right. Okay, so the sole condition imposed for the utilization of the testimony of a deceased witness is that the opposing party had the opportunity to cross-examine or to confront the same. So in People versus Harris, it says that the right can be waived. It says that where a party has had the opportunity to cross-examine an opposing witness but failed to avail himself of it, he necessarily forfeits the right to cross-examine, and the testimony given on direct examination of the witness will be received or allowed to remain in the record. Here, respondents chose the option not to ask for a continuance and reserve the right to continue with their line of questioning for trial proper. So, as mentioned during the fact. So, this means that they have waived the right to further confront or cross-examine their witness. But they were, again, able or they were given an opportunity to do so. They just waived the right to continue or to delve in further to exercise such rights. Respondents' reservation for trial proper of the right to further cross-examine Mendiola did not diminish the sufficiency of the opportunity that they were given to confront the adverse witnesses. Okay, so thus respondents' constitutional rights to confront and cross-examine the witness were not violated since the fair hearing envisaged by criminal due process had been complied with when the counsels for respondents conducted a rigorous and exhaustive cross-examination of the deceased witness during discharge hearing. Okay. Then we have People versus Mejia. So the right here is the right to be presumed innocent. Sorry. So the case is about an attack that happened on a driver and a passenger of a jeepney transportation in Pangasinan. So the attack was alleged to have been committed by several persons who had stabbed the driver, who is Landingin, and Katugas, who was the passenger witness, before they were thrown off the jeepney and the accused or the culprits sped away. As a result, Landingin died while Katugas was hospitalized due to severe injuries. So the accused for the case were Mejia, Benito, Paraan, Fabito, Kalimkim, Dennis, Mamaril, Mondragon, and another unidentified person. Kalimkim was later found dead from a gunshot. 3 separate criminal complaints for murder, frustrated murder, and violation of the Anti-Carnapping Act was filed against them in the MTC. So the prosecution during the hearing presented Katugas as one of their witnesses. So Katugas testified that he boarded the jeepney at around 7 p.m. on March 10, 1994. Later on, 9 other persons also boarded the jeepney. Later, or by the time they reached Nansangaan, Pangasinan, Mejia, one of the imputed accused, announced a holdup. All 9 passengers drew daggers, then stabbed Landingin and Katugas. Policeman Clemente, who is also a witness for the accused, stated that he saw 6 men and apprehended them because he saw them during the night and thought that they were an Akyat Bahay gang. But this was denied, and the policeman was later pointed to the abandoned jeepney of Landingin. On the other hand, so this is now the version of the defense. So they testified, specifically Benito. Benito was a driver actually of an elf truck, which hauls sand and gravel, and Mejia, Paraan, and Fabito were his helpers. So they alleged that they were not part of the Kalimkim group, but was actually just accidental passengers. They were not part of the group who committed the crime. So During the holdup, Benito said that Kalimkim pointed a knife at him while the others were ordered to lie on their belly. They were prevented from alighting the jeep, so they just followed the orders of Kalimkim and the rest of the men. But later they were able to run away. So when the policemen saw them, they told the former that they were not troubled persons and proceeded to tell the policeman what actually happened. The accused also testified that their parents met with Katugas to ask if their sons really did do the crime, just to confirm if they really, if Katugas really saw them do the crime. However, as a response, Katugas said that since the accused were the ones who were apprehended, he could just lie so that he could recover the amount he had spent on hospitalization, which amounted to 80,000 pesos. The trial court gave full credence to the version of the prosecution and convicted the accused of the crime of murder, frustrated murder, and carnapping. So the issue here is whether or not the prosecution established with moral certainty the guilt of the appellants. And the court ruled no. The prosecution failed to establish the respondent's guilt beyond reasonable doubt. So to overcome the presumption of innocence that is mandated in our Bill of Rights, nothing but proof beyond reasonable doubt must be established by the prosecution. Unless the prosecution successfully discharges that burden, the accused need not even offer evidence on their behalf. So here, the appellants defended that they were not part of the Kalimkim group, but rather they were just accidental passengers. However, this was not established or this was not debunked by the prosecution. They did not even offer evidence that would prove that they are actually part of the Kalimkim group. On the other hand, the appellants were able to provide to give more credence to their side because they were able to prove by circumstance that they were indeed not part of the Kalimkim group since they fled from the group when the first opportunity to do so came. The prosecution relied also solely on the testimony of Katugas, which left much to be desired, as provided by the court. So first, the prosecutor that conducted the direct examination on Katugas was unable to propound sensible questions to elicit clear answers bound to reconstruct faithfully the events surrounding the commission of the crime. And Katugas' testimony was also not consistent. So at first, he said that all 9 of the persons that were um, that that were imputed as the accused had stabbed him and Landingin. However, after a while, or when he was asked again, he said that only 6 of the accused. So it's not consistent. Number 2, the testimony of Katugas fails to convince us that the appellants indeed participated in the commission of the crimes. Third, Katugas categorically admitted that he did not know the names of the appellants and he could recognize only 3 of the 9 accused. And finally, Katugas was not entirely free from any ulterior motive in implicating the appellants. So again, he admitted that he demanded 80,000 pesos from the parents of the appellants, but before they could give the money on the agreed date, he testified against the appellants. Thus, the court ruled that they have serious doubts as to the guilt of the appellants and dismissed the case. Then the last case is Galman versus Pamaran. So the right of the accused here is the right against self-incrimination. So the case centers on the assassination of former Senator Benigno S. Aquino Jr. and it tackles or ascertains who was the real culprit of the crime. So in line with what happened or the tragedy that happened, PD 1886 was promulgated, which created an ad hoc fact-finding body, also known as the Agrava Board or AB. The AB was tasked to determine the facts and circumstances surrounding the killing, to have a free, unlimited, and exhaustive investigation of the tragedy, and also to conduct hearings. So they were given this privilege and task. So various witnesses appeared and testified and or produced evidence on their behalf or as mandated by the Agrava Board. Such witnesses included private respondents, General Fabian Ver, Major General Prospero Olivas, etc. So upon the termination of the investigation, reports were submitted to then President Marcos. Then later, 2 informations was filed for murder. One for the killing of Senator Aquino and another for killing Rolando Galman, who was also found dead on the airport tarmac. Upon arraignment, all the accused, including the private respondents, pleaded not guilty. So in the joint trial, the prosecution presented as part of its evidence the individual testimonies of the private respondents before the Agrava Board. This was contested by the respondents on the ground that this would be a violation of their constitutional right against self-incrimination. This was opposed, their contention was opposed by Tanod Bayan, contending that the immunity relied upon by the private respondents was not available to them because they failed to invoke their right against self-incrimination before the ad hoc fact-finding board. So the issue is whether or not the testimony before the Agrava board can be admitted as evidence in a criminal case filed against private respondents. The court ruled that no, for that would be violative of their right against self-incrimination. So before I delved into the ruling, so I wanted first to show you two of the pertinent provisions from PD 1886. So Section 4 states that the board may hold any person in direct or direct contempt and impose appropriate penalties. Therefore, for persons guilty of refusal to be sworn or to answer as witness or to subscribe to an affidavit or this deposition when lawfully required to do so, may be summarily adjudged in direct contempt by the board. Okay. Section 5 also states that no person shall be excused from attending and testifying or from producing books, records, correspondence, documents, or other evidence in obedience to a subpoena issued by the board on the ground that his testimony or the evidence required of him may tend to incriminate him or subject him to penalty or forfeiture. But his testimony or any evidence produced by him shall not be used against him in connection with any transaction, matter, or thing concerning which he is compelled after having invoked his privilege against self-incrimination to testify or produce evidence. So again, the testimonies provided by the private respondents during the Agrava board hearing should not be used or was ruled to not be used as evidence in the criminal case filed against them. Why? So a literal application of the requirement against self-incrimination states that the accused has the option to refuse to answer questions and therefore to make such claim. However, the right against self-incrimination, or basically the right of the accused to answer any questions and to remain silent, was denied by PD 1886, as can be seen by Section 4, since they risk being fined, cited in contempt, or being imprisoned. So similarly, they cannot invoke the right not to be a witness against themselves as well, because both these constitutional rights remain silent, to remain silent and not to be compelled was also foreclosed by PD 1886. And yet, when they testified and produced evidence as ordered, they were not immune from prosecution by reason of testimony against them. So the court ruled that the testimonies of the private respondents that they have provided during the Agrava board should not be used in evidence in the criminal case against them, because this will be violative of their right to self-incrimination. That is it for our group. Thank you for listening, and good night.